Hello everyone, my name is Anirudh and in this video I will be telling you the regulatory frameworks and the types of labor laws applicable in India. In this video you will be learning what is the constitutional framework that is governing the labor laws in India, and on the basis of purpose of enactment what are the types of labor laws, and on the basis of compliance also how the labor laws can be divided. So we will learn all these aspects in the video, so watch till the end. Let's understand the concept of division of legislative powers as per the constitution. So in the seventh schedule of the Indian constitution, which defines the allocation of powers between state and center. So as per the seventh schedule, it is divided into three lists. The first one is like union list. The union list is a list of 100 matters or subjects that are listed and which only the union government or the parliament or the central government has the exclusive power to frame law on those matters. So some of the examples of such matters are like defense matter, atomic energy, railways, highways, posts, banking, income tax, etc. So in this matter, only the union government or the central government have the power to frame and implement law. So the second list is called the state list. The state list or the list 2 is a list of 61 items which are listed in the state list of the constitution. So in the matters listed in this list, only the state government have the power to frame law in such matters. Such matters are like some of the examples are like police, revenue, prison, public, health, agriculture, etc. So in this matter, only the state government have the exclusive power to frame law. And the third list is the concurrent list or list 3. So in this list, 52 items are listed. So both the central government and state government can frame law in their respective jurisdictions. So some of the examples like criminal law, forests, trade unions, industrial and labor disputes, social security, employment and unemployment, labor welfare, trade and commerce, etc. Since the labor matters and the employment, unemployed matters, trade union matters, trade and commerce matters, all the labor related matters are listed in the concurrent list of the Indian Constitution. Therefore, we can witness in India there are state specific labor laws. Also, there are some labor laws which is framed by the central government and that is applicable to the industries for which the appropriate government is the central government. Let's understand the categories of labor laws in India. So, based on the purpose of the enactment of the labor laws, it is divided into four types. So, the types are like first one is the protective labor legislation, the second is the regulative labor legislation, the third is the social security legislation, and the fourth one is the welfare related labor legislation. So let's understand the what is protective labor legislations. The protective labor legislations are those legislations whose primary purpose is to protect the minimum labor standards in the area of safe working environment, employment of children and women, wage payment, and improve working conditions, etc. So basically, these labor laws protect the labor standards. It helps and it provides the guidelines how the employer will maintain safe working environment for employees, how the wages to be paid fairly and in a time manner, and also it provides certain restriction on the employment of children and women at workplace. So these are the major 16 labor laws, so which is in the category of protective labor legislation. So those labor legislation are like Factories Act 1948, the Mines Act 1952, the Plantation Labor Act 1951, the Motor Transport Workers Act 1961, the Shops and Commercial Establishment Act 1953, the Payment of Wages Act 1936, the Minimum Wages Act 1948, the Equal Remuneration Act 1976, the Child Labor Prohibition and Regulation Act 1986, the Contract Labor Act 1970, the Interstate Migrant Workmen Act 1979, the Payment of Bonus Act 1965, the Apprentice Act 1961, the Building and Other Construction Workers Regulation of Employment and Conditions of Service Act 1996. And the 15th is the Working Journalist and Other Newspaper Employees Act 1955, and the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. So these are the protective level laws. The second category is regulative labor legislations. So the legislation's primary purpose is to regulate the relations between employers and employees and to provide manners and methods of settling the industrial disputes. It's called regulative labor legislation, or it may be called as industrial relation labor legislations. So these three labor legislation that are coming under regulative labor legislations are the Trade Union Act 1926, the Industrial Dispute Act 1947, the Industrial Employment and Standing Order Act 1946. And the third category is the social security labor legislations. So these social security labor legislation which provides the social security benefits to the workmen and their families during the contingencies period of their life. So those labor legislation are like Workmen's Compensation Act 1923, the Employees State Insurance Act 1948, the Coal Mines Provident Fund and Miscellaneous Provision Act 1948, the Employees Provident Fund and Miscellaneous Provision Act 1952, the Maternity Benefit Act 1961, the Payment of Gratuity Act 1972. The, the fourth category is welfare labor legislations. The labor laws which aim at providing the general welfare of the workers and improve their living conditions are welfare labor laws. Such laws carry the term welfare in their titles. So these are the five welfare related labor laws, major welfare related labor laws. So that are Mica Mines Labor Welfare Fund 1946, Iron Ore Mines, Manganese Ore Mines and Chromite Ore Mines Labor Welfare Fund 1976, BD Workers Welfare Fund Act 1976, the Cine Workers Welfare Fund 1981, the Building and Other Construction Workers Act, SES Act 1996. Again, we can divide labor laws based on the compulsory license or registration obtained by the employer. So based on the category, the first category is like the compulsory registration and license to be obtained by the employer from the competent authority as per the applicability under state or central rule. So these are the 11 labor laws for which employer need to obtain a license or registration or take a code under the acts. So under Factories Act, Mines Act, Plantation Labor Act, Motor Transport Works, and Shops and Commercial Establishment Act, the Contract Labor Regulation Act, the Interstate Migrant Workmen Act. For these seven labor laws, the employer need to obtain a license from the concerned licensing authority, and those license to be amended as applicable, and it should be renewed time to time. And for the next three, like the Employees State Insurance Act, the Coal Mines Provident Fund Act, the Employees Provident Fund and Miscellaneous Act, for these three labor laws, the employer need to obtain a code from the concerned department, and the employees need to be registered under those codes, and the contribution defined by the government both from employer and employee side need to be deposited to the concerned account on the timely manner. And in the last level of the Apprentice Act 1961, the employer need to register the apprentices in the central government's portal uh, as per the given timeline. The another kind of labor law for which no license registration required, but it is applicable to every kind of industry. So these are the nine labor laws for which employer need not to obtain any license or registration under the Act. Under the Payment of Wages Act 1936, employer need to pay correct and timely wages to the employees. Under the Minimum Wages Act, employer need to comply the minimum wages prescribed by the appropriate government. Under the Equal Remuneration Act, employer need to ensure the equal wages paid for equal work. Under the Child Labor Act 1986, employer need to comply. No child labor should be allowed to work inside the factory, and the abstract under the act should be displayed in front of the establishment. Under the Payment of Bonus Act 1965, employer need to ensure all the eligible employees are paid the bonus as per the method and criteria mentioned under the Payment of Bonus Act 1965. Under the Sexual Harassment Act at of women at workplace, the employer need to frame an internal complaints committee to prevent, prohibit, and redress the matters related to sexual harassment. Under the Workmen Compensation Act 1923, employer should ensure the compensation is being paid to the employees who are facing accident, death, etc. Under the Maternity Benefit Act, the eligible female employees should get the proper and accurate benefit mentioned under the Act. And the Payment of Gratuity Act 1972 provides the gratuity to be paid after the completion of the prescribed service period. So, irrespective of taking any registration or license, employer need to comply under these labor laws. In my coming videos, I will be explaining in detail about these labor laws. So, thank you for watching.